Okay, everyone, welcome to the Module 3 live session for the contracts course. This meeting is being recorded in case you would like to watch it later. Let's see what's going on in Module 3. Well, we are taking a look at the Uniform Commercial Code, looking at the provisions on offer and acceptance. In the Restatement of Contracts, which is basically a treatise, we're looking at Chapter 3 on the making of offers. We've got a written assignment this week, a discussion forum, and a quiz. So it's actually a busy week in the course. Unfortunately, we are going to have a quiz review to make everything a lot easier, Natalie. So let's talk about this written assignment first. We have a scenario where your firm would like to update its research notes that it keeps in an electronic folder on the topic of offer and acceptance. So it is asking you, the paralegal, to analyze and write a memo about some contract issues. So this is going to require you to do research on Lexis Advance or Fast Case. So you will need to find a recent case on offer and acceptance by doing a search. Be sure to sort by newest to oldest date so that the one that comes up on top is the most recent. Be sure that it is indeed a case where the court analyzes the elements of offer and acceptance. So as you're learning to do legal research, Natalie, one thing you'll want to do is really learn how to narrow down your search results to really get the hit, and that's the case that you really want. So if I was to do a search on Fast Case, I would get all kind of cases, but I only want one on offer and acceptance. So let me actually demonstrate that. Let me show you how I would do this search. So I'm going to share my web browser. We're going to go into the online course where I've posted a link to Fast Case. And we're going to do this search together to see what we get. Does that sound good, Natalie? Great. So last week I posted a link to Fast Case. There it is. Okay, so what we want is a case on offer and acceptance, and I'm going to narrow my jurisdiction down to Minnesota. All right, I've got that selected. Save and continue. And what I want is a case on contract common law, offer and acceptance formation. So I have 40 results. I would like the newest case. So I'm looking over here to the right hand side. There's a word called relevance. I'm going to sort by date with the newest case on top. Perfect. Now I've got a case from 2021. Let me see what the summary tells me. This case, applying the city's rule of law, the express disclaimers located in the introduction of the handbook as a matter of law, conclusively defeated the formation of a contract requiring payment of accrued paid time off because the city never made an offer to contract. So this would be a case about offer and acceptance, offer to contract, and it looks like it's within the area of employment law. The judge says this case raises two related questions arising from an employer's refusal to pay paid time off when an employee's employment ended. First, due to disclaimer provisions in an employee handbook stating that the handbook policy should not be construed as a contract, unambiguously allow an employer to refuse to pay accrued paid time off. Second, does Minnesota Statute 181-13 create an independent substantive right to payment in the absence of a contract. So looks like the main issue in this case is about the paid time off. Let me see if there's enough talk about contracts really for me to cite this as a contract law case. Well, there's a claim about breach of contract. And the court says this case involves issues of contract interpretation. Question is whether the employment handbook is a binding contract. So I'm not particularly happy with this case because it's the contract issue is involved, but the main issue is the employment law issue about the paid time off. So let me look at my next hit and see if that case might be one that I would be willing to cite to in an assignment or in a memo. Now, in this case, the parties did not memorialize their agreement. So the issue is whether there's an oral contract that's been formed. The issue is taking a possession of a cat. Okay. The parties did not memorialize the agreement regarding Oliver's placement in Hamilton's care. Formation of a contract requires an offer that's communicated, acceptance of the offer, and consideration. So this is actually a very good case to cite because there's a central discussion about whether an oral contract was formed. The court is citing to the traditional principles of offer, acceptance, and consideration. So I would consider this to be a very good case to cite for your Module 3 assignment. Do you think this is a good case, Natalie, on offer, acceptance, and consideration? Yeah, I mean, looking at the terms, when you do your search and you get a case that comes up in your research results, I see that my search terms are highlighted. Formation of a contract, offer, acceptance, consideration. It's one of the central issues in the case is whether an oral contract was formed. So I would cite to this case in my memo. Let's look at the next hit. Kuzak versus Mosey's Concrete and Masonry. Sounds like a service contract. In this appeal from a final judgment, there's an issue about enforcing a settlement agreement. You know, I do not think that I would cite to this case. Because it's more about the settlement agreement than it is about the details of a contract. They are trying to figure out whether the settlement agreement's enforceable. A full and enforceable settlement agreement requires a definite offer and an acceptance, a meeting of the minds. So you could cite to this case, but it's more about the settlement offer than the contract. So the second case is the one that I like the most so far when it comes to formation of an offer and looking at the formation of a contract, the elements of offer, acceptance, and consideration. So that would be one way to start your research for this assignment. Any questions or observations, Natalie? Awesome. So the next part says find a recent article or blog on the web. Well, let's try that. Let me share my web browser with you again. When it comes to searching the web, I like to use Google. So that's what we're going to do. Go to Google. So now I'm looking for a legal blog on contract, offer, acceptance, and consideration. When is a contract enforceable? Black and Davidson. So this is like, this is probably a law firm's website. They have a blog and they're talking about when an offer and acceptance can form a contract. So this is one that you could Cite 2. Here's an example where the offer is clearly made in jest. I will pay you $1 million for that sandwich. Would you consider that an offer, Natalie, if you were eating a tuna fish sandwich and someone says, I will pay you $1 million for that sandwich?
I mean, I guess it's kind of an offer, but I don't know. That's a weird one.
Would you take that seriously?
Not for $1 million, just for
No.
like a sandwich.
Now, if I said I'll pay you $5 for that sandwich.
Then maybe I'd consider it.
Okay, good. Here's an example where the language is clearly exploratory. Would you consider $500 for that guitar? Does that sound like an offer?
Yes, but also like guitars are pretty expensive, so I kind of feel like it would be a little like underselling for it.
Yep. Well, guitars range anywhere from, I would say, like 200 to, if it's something that was played by, Eric Clapton, 30,000, but that's a valid offer. You could get a decent guitar these days for $500 in this time of inflation. So that could be considered as a serious offer. Would you consider taking $500 for that guitar? Depending on what the guitar is. So this blog looks like it would give you some information about offer and acceptance. So this would be acceptable. And that was my first hit on Google. Here's another one, offer and acceptance online, SEQ Legal. They've got their own blog. There are 3 fundamental requirements for formation of a legally enforceable contract. They are as follows. So I don't see any problem with getting the research that you need for this Module 3 assignment right off the internet. Do you see any problems with it, Natalie?
For like getting the blogs off the internet. Um, just like really watch what blogs you get it from, because like some people put false information out there, so when I do research, I just have to pay attention if the site looks legit, because some of them really do look legit and they're not.
Okay, good. Yes, we always want to look for reliable sources. All right, so the third part of the assignment is to ask yourself which of the sources helped you most in understanding the law of offer and acceptance and why. Fourth, find and cite an applicable portion of offer and acceptance in the UCC or the Restatement of Contracts. Use Blue Book citations just below each. The only thing that should be uncited in the paper needs to be your personal analysis. So I would just answer these questions in order in a memorandum, double spaced, using Blue Book citations. Any questions about that, Natalie, before we move on? All right. So this week we're getting into our discussion forum. This is the first week that we've had a discussion forum in the contracts course. And it's a very interesting scenario we'll be discussing. It involves your supervising attorney, Joe. So you are the paralegal. Joe is your supervising attorney. Joe would like to enter into an agreement to help her cousins, Harry and Dean, buy a boat. So Joe wants to loan them 20% of the price of the boat in exchange for a promissory note and like a lien interest in the boat until it's paid off. Harry will use Joe as his attorney. Dean does not want to have a lawyer review it. So do you see any ethical conflicts here, Natalie, in this scenario?
Mm, for one, they're all cousins, so that's a big one for me, but also the fact that he doesn't want an attorney to look over it is also kind of a red flag, because you should always have somebody else review it if you have conflicts.
Good, good. So Natalie sees that there's some rules at issue. Let's look at ABA 4-3, dealing with an unrepresented person. And these are rules that you may remember from your legal ethics course. In dealing on behalf of a client with a person who is not represented by an attorney, the lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer needs to make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than that you need to go secure your own counsel. If the lawyer knows that the interests of the person have a reasonable possibility in being in conflict with the interests of the attorney or the client. So in our scenario, Joe's interest would be different from Dean's because Joe is going to loan Harry and Dean the money for the boat, becoming their creditor. They become his debtor, and Joe also gets a lien on the boat and a promissory note. So they could have conflicting interests. So Dean would need a separate attorney to review the case. And Harry wants Joe to be his lawyer. And really, Harry might need another to seek outside counsel too, because Joe has an interest in this transaction that might be opposite of Harry and Dean's interest, since he's going to become their creditor. So, Rule 1-8, current clients and transactions. Here are the rules. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory security, or other pecuniary interest adverse to the client unless the transaction, the terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can reasonably be understood by the client. The client is advised in writing of the desirability of seeking independent legal counsel. The client gives informed consent in writing to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is indeed representing the client in the transaction. ABA Rule 1-8. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of the litigation the lawyer is conducting for a client, except the lawyer may acquire a lien, but only to secure attorney's fees, not to secure the lawyer's interest in the boat. Okay. The lawyer can contract with the client, but only for reasonable contingency fees. The lawyer cannot contract with the client for a security interest and a promissory note in the boat. So those are the issues that you'll be discussing in the Module 2 discussion forum. So is there a conflict of interest, Natalie, in this case?
There is, just because for the fact that they're all cousins. I think they're all cousins, or a few of them are, but that's a conflict of interest.
Okay, it's not the fact that they're cousins. An attorney could represent a cousin, but the problem is that they're on opposite sides of the transaction. The attorney is going to loan Harry and Dean money. So the attorney becomes their
Oh,
creditor. They become his debtor. And see, now they're on opposite sides.
okay, that makes more sense.
It's okay to represent a cousin. A lawyer could represent a cousin. An attorney could represent his wife. Um, an attorney could represent her husband. An attorney could represent their parents. That's okay. But what is not okay is for the attorney to have an adverse interest to a client. And in this case, Harry wants Joe to turn their agreement to purchase the boat into a written contract. Harry is going to pay Joe for drafting the contract, but Dean does not want to have his own lawyer. So I think there's a conflict of interest here. And it's not because they're cousins, it's because Joe is the attorney who is drafting the contract, but he's also getting a security interest in the boat. He's loaning money on the boat, and he's going to get a promissory note, which, he's essentially got a lien on the boat. And Harry and Dean become his creditor. He's a creditor. They become his debtors in this transaction. So That would be a conflict of interest, and it's forbidden by 1-8. A lawyer shall not enter into a business transaction with a client. So when we're doing our Iraq analysis, we're looking at the issue. The issue is whether there's a conflict of interest. Well, what's the rule? It's Rule 1.8. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory security, or other pecuniary interest adverse to a client, period. So Rule 1.8, Section A forbids this transaction. So basically, you'll just need to talk about that in the discussion forum. First post was due Tuesday. You still have time to make it. And the reply post is due by Saturday. Just be sure to reply to my comments or reply to a classmate's comments in the discussion forum. Any questions before we start talking about the quiz, Natalie? Great. So it's a busy week in the course. You have your Module 3 quiz, which I helped to revise the quiz. And I took the quiz. I got an A on the quiz, so it can be passed. After having taken the quiz, I came up with this list of review topics. Here is what you need to know for the Module 3 quiz. What are the 3 elements of a valid contract? Can you remember that off the top of your head, Natalie? What are the 3 elements of a valid contract?
I know it's offer, acceptance, and then there was one more, but I can't remember off the top of my head. I know it starts with a C. It's like, oh, what is it? Um,
Consideration. I was
there
trying
we
to
go.
do sign language.
I know sign language, but I couldn't catch it.
CONSER. Yes, so it's consideration. So what are the 3 elements of a valid contract? Offer, acceptance, and consideration. Natalie, do contracts have to be in writing?
No, they can
Nope.
be orally.
Good. According to English common law, which was brought over from America, which was brought to America, contracts can be oral. Some attorneys would prefer that the contract be in writing, might make it easier to enforce in court, but oral contracts are perfectly enforceable. So if your neighbor says, I will mow your lawn for $10, you give them $10, they mow the lawn. That is a valid contract, does not have to be in writing. If your neighbor or your friend or a contractor says, I will repair your roof for $5,000, that's a valid contract, does not have to be in writing. All of the terms do not need to be stated either, just the material terms. The court can find that there is a contract, and the court can then use evidence to ascertain what the terms of the contract are. What law would apply to contracts for the sale of goods over $500? What rules?
That one I don't know, so I'd have to do more studying on that. The ABA model rules or no?
UCC.
Oh, UCC, there we go.
So the Uniform Commercial Code is a set of special rules to facilitate the sale of goods and uphold commercial contracts. So the Uniform Commercial Code has been adopted in part by every state, and it's codified in the state statutes, and it applies to contracts for the sale of goods over $500. If you're dealing with a personal services contract, which would be, an athlete has a contract with the NBA to play basketball, or if I hire Britney Spears to sing at my birthday party, that would be her providing a service. That'd be a service contract in which the common law applies. Common law is just judge-made law that's been developed through cases, through it's judge-made law. We can figure out what the common law is by looking at cases. Sometimes it's also found in treatises, textbooks, encyclopedias. Okay. Does acceptance have to mirror the terms of the offer?
Yes.
Yes, you're right. It does. So if I offer to buy your sandwich for $5 and you say yes, it's not that you've agreed to $6, it's that you've agreed to the $5. And it's not that you've agreed to half of the sandwich, you've agreed to the sandwich because the acceptance has to mirror the terms of the offer for us to have a meeting of the minds. Contract law is about protecting the parties' intentions as shown by the meeting of the minds. Okay, Natalie, what is consideration?
Is it like the goods, so like the money, it can also be like the service like they promise to provide for the like offer and acceptance of the contract?
Excellent. Excellent. So yes, consideration is the third element of a valid contract. It is something of legal value that is bargained for. It is usually the subject matter of the contract. Why would you put a contract in writing, Natalie?
Just for like holding it up in court so that the other person can't be like, oh, I didn't say that. That way you have every single like term and condition that they were supposed to do. And that way too, like it helps you win the case if they're in the wrong.
Good. And the best way for a lawyer to write a contract is using plain language, not a lot of legalese, but just plain language. What should a paralegal do if she finds an error in a contract, Natalie?
Don't they bring it attention to their like supervising attorney so that they can make that correction?
Good. You were right. Okay. Last week we talked about Iraq as opposed to the Iraq, the nation. What does Iraq stand for? It's an acronym. An acronym is where you take one letter of the first word of a phrase and come up with a word like Iraq. But what does Iraq actually stand for, Natalie?
Issue, rule, analysis, and conclusion?
Perfect.
Or no?
Perfect.
Okay.
You got it. So we use IRAC tables in Microsoft Word to help us identify, analyze, and reach conclusions about a legal case or a scenario that we're working on. Helps us to analyze the case and identify what facts we know, what issues we have, and what more information that we need. The restatement second of contracts is a treatise about contracts. It's like an encyclopedia. It is a secondary source of the law. Cases and statutes and rules are primary sources of law. An encyclopedia of the law, like the restatement of contracts, is a secondary source. Why would you use a Lexis Advance or Fastcase? Have you used those at work before, Natalie?
I did for the last like legal memo we had to write for part of our trial notebook and stuff like that. So that was actually pretty interesting just because I already had experience in the class, so it was very helpful.
Great. What did you think were the best features of Lex? Did you use Lexis Advance?
I used Fastcase just because I
Okay,
like being able to type in and like finding the most recent cases, which is really helpful to me.
good. So yes, Lexis Advance and Fastcase are premier legal research services. They are boutique services that we pay for, or the school pays for, or your law firm, your supervising attorney pays for, so that you have access to reliable legal research services. Okay. Last week we talked about the Uniform Commercial Code again. Um, the UCC has special rules for contracts for the sale of goods to uphold these consumer commercial transactions. Under the UCC, the seller has special duties to deliver the goods, deliver conforming goods, to cure any errors if necessary, and to, accept payment of goods. Under the UCC, the buyer has a list of duties. The buyer's duties are to pay for the goods, to accept delivery, to notify the seller if the goods are non-conforming, and to cover if if the seller fails to cure a defective delivery, the buyer can cover by seeking alternative goods from someone else. And those duties are spelled out in your textbook and in Module 2. So, under the UCC, what are the seller's remedies? You should look that up. And it's usually to sue for payment, to attempt to cure a defective delivery. Buyer's remedies are to sue the seller for specific performance, excuse me, to sue for breach of contract, to sue for damages. UCC is an acronym for the Uniform Commercial Code. What is the purpose of the UCC? It's to uphold smooth commercial transactions for the sale of goods. So these are the topics that I would review. I would look over your notes. I would look over the information, especially in Module 2 about the UCC, to make sure that you are aware of the answers to these questions. Any questions about what might be on the quiz, Natalie? Okay, great. You should be ready to take the module quiz after you have reviewed that information. So please be sure to submit the correct quiz answers by Sunday, October 24th. There is no live session question this week. Just be sure to take the quiz. And if you should need any help doing your Module 3 written assignment, you can set up a tutoring appointment. Contact me. I will set it up. If you need any help using Lexis Advance or any of the library services like Fastcase, please contact Dennis, the librarian. I posted a link for you to contact the librarian. I posted an announcement today. Again, if your computer crashes, call tech support. Otherwise, this concludes our Module 3 live session. Have a great week. Any other questions or concerns, Natalie?
I should be good. Thank you so much.
Oh, thank you for attending the live session. See you next week.
See you next week.
Bye.